This analysis is submitted to demonstrate that a conviction is unsafe. The conviction was predicated on a body of evidence that was fundamentally tainted from its inception by a signal failure of the investigating police force to discharge its duties impartially. The central submission is that the police misconduct themselves by elevating an initial 999 call from the complainant to the status of dispositive proof of the mens rea and actus reus of an assault. They did so by failing to subject the call to any critical scrutiny, despite manifest indicia that the complainant was not a victim in fear, but rather a composed and calculating actor engaged in a performative exercise designed to criminalize the appellant. This foundational failure created an irreversible chain of confirmation bias, whereby all subsequent evidence was interpreted, and in some cases distorted, to fit a predetermined narrative of guilt. This constitutes an abuse of process so profound as to render the subsequent conviction unsafe. It is a cornerstone of English law that a police investigation must be conducted with fairness and impartiality. This duty is enshrined in the Code of Ethics and the Criminal Procedure and Investigations Act 1996, CPIA. This includes the duty to pursue all reasonable lines of inquiry, whether they point towards or away from the suspect. The police's handling of the 999 call represents a wholesale abdication of this duty. They failed to pursue the most obvious and reasonable line of inquiry, whether the complainant's conduct was consistent with his allegation of being in fear. The prosecution advanced the 999 call as a contemporaneous record of the complainant's genuine fear. A proper analysis of the call's features, as documented in the police's own logs, reveals the opposite. The police were faced with and chose to ignore the following powerful contra-indicators. The deliberate use of the loudspeaker. This act is irreconcilable with the behavior of a person in genuine fear of an aggressor who is, by the complainant's own account, right in front of him. It is an act of overt provocation. Its purpose can only have been to ensure the appellant was aware of the report being made, thereby maximizing the potential for an angry reaction that would be captured for the benefit of the police operator. For the police to have accepted this as a safety tactic without challenge is, with respect, an absurdity. It is a failure to apply common sense, let alone investigative rigor. B. The complainant's composure and narrative control. The log documents a complainant who is not in a state of panic, but who is providing a structured, sequential, and analytical account of events. He is not pleading for aid, he is giving a statement. He confirms, with notable composure, that the alleged weapon has been secured. Hi Mum took it away from him. This confirmation that the immediate threat had passed fatally undermines the prosecution's assertion of a continuing apprehension of immediate unlawful violence, a requisite element of the offense of psychic assault. C. Active participation in the dispute. The complainant is documented engaging directly with the appellant during the call, refuting an allegation by stating, "That's a lie." This is not the conduct of a terrified victim seeking refuge. It is the conduct of an active participant in a continuing verbal altercation, confident enough to argue his case while a police operator listens in. Having uncritically accepted the 999 call as the unimpeachable truth, the police investigation proceeded on a false premise. This led to a cascade of investigative failures, all flowing from the initial confirmation bias. Failure to investigate the counter-allegation. The appellant's contemporaneous report that he was intervening to protect his daughter from the complainant's verbal abuse was not investigated. It was dismissed as a self-serving denial. This was a gross failure to pursue a reasonable line of inquiry that could have provided crucial context and supported a defense of prevention of a crime or defense of another. B. Prejudicial interpretation of evidence. The appellant's actions were interpreted in the most incriminating light possible, without any objective consideration of his alternative explanation. An act of moving a knife for safety became brandishing a weapon. An act of creating a barrier with a toy became throwing an object. This is not impartial evidence gathering. It is the construction of a prosecution case. C. Invalidation of exculpatory evidence. When a key prosecution witness sought to withdraw her statement, her retraction was not treated as evidence that her initial account may have been mistaken or given under pressure. Instead, it was framed through the biased lens of intimidated domestic abuse victim, with the police using a subsequent, unrelated report to bolster this prejudicial narrative and ensure her initial, incriminating statement remained the focus. The police did not merely fail to investigate. They engaged in an exercise of narrative construction based on a foundation they knew, or should have known, was profoundly unsafe. They adopted the complainant's performance of fear as fact and, in doing so, became co-authors of his narrative. This is not a case of minor procedural errors. It is a case where the police, through a combination of willful blindness and confirmation bias, failed to discharge their most fundamental duties. They pursued a prosecution not because the evidence was unequivocal, but because they had accepted, from the first moments of the 999 call, a version of events that was never subjected to the critical, impartial scrutiny the law demands. For these reasons, the resulting conviction is fundamentally unsafe and constitutes a miscarriage of justice. It is submitted that the appeal must be allowed and the conviction quashed.